Okay, item 28, WPS 6310 of 2015.
Please, your lordships. I have filed, my lord, 2 IAs. And earlier also 2 IAs actually, my lord, this case traveled to me only recently, 10, 15 days, 20 days back, my lords, we filed Wakalatnama. So, the account I am representing Bokaro Mahila College and the bank account, my lord, maintained in IDBI Bank Bokaro. It has been, my lord, attached by the Provident Fund Commissioner, my lord. So, there in one IA, my lords, IA number 10199 2024.
The pleadings are complete. You argue the case.
Yes.
You argue the case, we will decide it.
So, this IA, my lords,
There is no question of any interim relief. The matter is ready for hearing. You argue it. I will decide it right away.
this earlier writ, my lord, what has happened? That earlier writ was filed, my lord. There also 2 full prayers were made for quashing the order passed under section 7Q14B, my lords.
And where is the other side? Did you inform the
I
other
have
side?
informed and I have
Who is the
verbally,
other side?
I have verbally informed
Who is the other side? Which
Mr.
counsel?
Rupesh Singh. Mr. Rupesh Singh.
Mr. Rupesh.
Yes, yes.
Mr. Rupesh Singh का नाम ले लो.
My lord, we don't have any quarrel on making payment. They have raised a demand, my lord.
He's coming in addition.
My lord, they have, if my lords will kindly peruse for a moment the attachment order, my lords. That is in IA number
I
101.
don't understand. You just come to the impugned order,
Yes.
main order. The case is otherwise ready or not ready.
My lord, the case, my lord, the IA,
We are not on IA. When the case is absolutely ready for final hearing, there is a question of IA.
yes, then it may be decided, my lords. IA for,
I'm hearing it. I told the counsel who had mentioned that
No.
we will hear it finally.
my lords, as regards the writ petition, the original writ filed in 2015, counter has been filed, rejoinder has been filed, but what has happened with passage of time, my lords, those matters it has in a sense merged, my lord, because they are carrying forward the dues, the remittances which is due against the college, my lord. And so it has culminated and merged in the IA itself. Therefore, my lords, all those matters, because
You see, if the impugned order is set aside, the entire castle built on that impugned order will automatically follow. You straight away come to the cause of action, the impugned order.
so here, my lord, here, then my lord, I will pray that my lords will kindly take this IA number 10518 first, my lord. Because the current cause of action, my lord, those cause of action, what has happened, my lord, that earlier 65 lakhs was due. Now it has swelled up to 1 crore 35 lakhs.
It will. The interest will go on running.
Yes, yes.
So there is no problem about it.
So therefore, my lord, now
The interest will not be arrested.
no,
If the impugned order goes, your entire grievance will be resolved. Yes or no?
my lord, yes, my lord, correct. But my lord, I am not challenging. I am challenging only for the reason that they have not taken into account the remittances sent by us. We have paid 1 crore.
You see that accounting is a different part of it. We are not here to do your accounting.
Yes, yes, my lord.
You just concentrate on the main impugned order. If we are satisfied that the impugned order is fit to be set aside, everything which flows out of the impugned order has to go.
So only 2, my lord. There are some recurrent IAs. The impugned order in one
You
IA.
are repeating the same thing. We'll just observe that all the interim orders, or everything which flows out, suppose we set aside the impugned order, then whatever flows out of the impugned order, that will be taken care of. For that, you see, it is like, you have a bill, right? and there is a recurring charges of maybe 20% interest. So every month you will have a bill with that 20% interest increased,
Yes.
right? There could be some remittances made by you and the manner in which they will adjust. These are all, but if the original bill is set aside, everything is taken care of.
In this case, madam, the situation is like this, madam. That
You see, we have taken up this case out of turn with a clear understanding that you will argue the case.
yes, I'm ready
You
for-
argue you forget about the IS. You argue the main case.
But my lord, now culminating, my lord, the main case. Yes, my lords, you kindly see the main case. The writ petition. In the writ petition, my lord, two orders were challenged. One is at page annexure 3, page 32-33.
Let us see your prayer.
First prayer is my lord. For Shashurari, my lords have got at page 3 the prayer is. For crashing of order dated 1715 under section 7A with section 14B and 17 of employee provident funds 52, and also for crashing of order dated 14/8/2015 passed under section 7B of the act passed by Sri Prabhat Sinha, the respondent number 3, who has no jurisdiction to pass above said orders. These are the two prayers. We have challenged because he had no jurisdiction, he was posted in ad hoc capacity. But now at this stage, my lord, since I have perused the file, my lords, I don't want to press the second prayer that he was not working de jure or de facto or whatever it is he was in. So this prayer I am not pressing.
Then the other impugned orders are appealable orders.
Pardon, my lord.
They are all appealable orders.
They are appealable, my lord. They are
You
appealable.
see, you challenge the writ petition by saying that they have no jurisdiction. Now you want to give up the point of jurisdiction. Go and file your appeal.
Therefore, my lords, I only pray, my lords.
Because
That's
this will
what-
require, there is a reason for that. You see, in old matters, we are not interested in remitting you for appeal. But the point is, there is a tribunal. These are all fact-finding things. But what payment was made, and what was the dues, how they were adjusted. So how
This,
do
my
we
lords,
decide?
under 226, my lords, is not going to calculate and quantify. It is only a case of judicial review. My lords, I have filed the IA only due to urgency, and therefore it was mentioned, my lord. And therefore, if my lords will hear me for 5 minutes, because my lords, I will show that I have paid prima facie. I don't want to, my lord, draw my lord into the deep into mathematics and all those calculations. But prima facie, I want to establish, my lord, that out of dues under 14B and 7Q, my lord, total amount. If my lords will kindly come to my IA for a moment, my lords. That is no 10199. And if my lords will see at page 2021, that is the attachment order of attachment, my lord, under section 8F, annexure 14, my lords.
10518.
There are two IAs filed
I
not signed.
am arguing from 10199. 10199.
What is your prayer? Can you read it? Can you read your prayer in this IA?
For quashing of impugned order as contained in letter number such and such issued by Assistant Provident Fund Commissioner Regional Office Jharkhand, by which an amount of 64 crores 58 lakhs towards damages for delayed payment. My lord, this I am reading from the petition. I am sorry, I'm reading my prayer in the IE. IMI. That was prayer in the writ petition for. First prayer is that instant IA is being filed for quashing of impugned order of attachment as contained in order number such and such, dated 12/8/2024, annexure 14, issued by Assistant Provident Fund Commissioner, by which account of Mahila College, Bokaro Mahila College maintained in IDBI Bank, Bokaro, has been attached for realizing a sum of rupees 1 crore 34 lakhs under. And my lord, second prayer is for impeding the Assistant Provident Fund Commissioner Bokaro. Earlier it was from Ranchi only, my lord. Now at Bokaro also some sort of camp office letters are being issued. So for impeding him as a party. These are the main prayers.
Your prayer in the idea is that the attachment should be stayed till the final disposal of the writ petition. And I want to hear the writ petition. I just don't understand.
Not till final, my lord.
You just please have a look at it. For staying the operation of the impugned order of attachment as contained in such and such, dated 12/8/2024, issued by Assistant Provident Fund Commissioner Bokaro till final disposal of the writ petition. The writ petition is absolutely ready for final disposal, and I'm asking you to argue the writ petition. You are not ready.
No, my lords.
I will not pass any order or any interim order when the court is ready to hear the matter finally.
My lords, I am only praying it may again be fixed after 2 weeks, my
No,
lord.
why? I'm hearing it today, I can fix it tomorrow. If you are not ready, but you have to say that you are not ready to argue the
No,
case.
I am ready, my lord.
तो argue, I'm hearing you. What's the big deal about it? 1 घंटा में नहीं होगा क्या?
1 घंटा तो लगेगा ही नहीं.
लगेगा ही नहीं. वही तो बोल रहे हैं आप. 15 मिनट से हमको आईए में घुमा रहे हैं.
Now you.
मेन रिट पिटीशन बहस नहीं कर रहे.
हम इसमें अब हमारा चूंकि प्रेयर कन्वर्ज कर गया, रीट का पिटीशन जो रीट का प्रेयर जो है, आई एम फॉरगोइंग माय लॉर्ड. रीट प्रेयर्स आई एम फॉरगोइंग. Now
If you forego your writ petition's prayer,
no,
then
it
no
has-
no
of course.
relief can be granted in your interlocutory application. Because your prayer in the interlocutory application has to be a sequel to your writ prayer.
Yes, it is a sequence. Earlier it was for 64 lakhs. Now it has swelled up to.
It will. अगर 5 साल और रह गया तो 2 करोड़ हो जाए.
तो इसीलिए माय लॉर्ड हम इसको हम 10 मिनट में आर्ग्यू करके फिनिश करेंगे पूरा केस. हमारा आईए में ही आप आईए ये नाम के लिए प्लीज डोंट बी माय लॉर्ड स्वेड अवे बाय द nomenclature of IE. My lords, because I have studied the file a little bit and it has come recently only.
And I have not studied it because it has been mentioned out of
But
turn.
my lord is very well acquainted with
No,
all
no.
these laws.
It's
I have
not.
got judgments
You
also
see,
recently
please.
also. My lord has passed judgments in one brick matter. All judgments. But that
Brick
was on
matter.
14B.
14B का अभी तो किए. सेवा सदन तो पुराना हो.
जुलाई या जुलाई में. My
अभी
lord.
एक किए हैं, अब वो नहीं देखे.
All Bihar file.
ये ना भी.
I have got the
4 days
judgment.
back.
4 days back में.
Bengal, I have got the judgment. I know. But my lord.
इसका
all-
केस नंबर बताइए, हमारे ऑफिस को नहीं पता है. 4 दिन पहले हम
I'll
जजमेंट.
give a copy.
केस नंबर बताइए.
केस नंबर है 6155/2010. तो ये सब
आप थे पिटिशनर, कौन था पिटिशनर?
No, no. Petitioner was.
Yes,
India was the petitioner, but represented by another panel.
ये हम पढ़े हैं लेकिन ये सब आई नो
सर देखिए, एक चीज आपको बता रहे हैं.
मैं लॉ इज वेरी हार्श.
Yes, law is very harsh.
Krishna
It is a
here has said-
welfare legislation.
Fair legislation, it is a beneficial legislation.
Yes.
Law is harsh. It is for the benefit of the employees.
Yes.
But if my lord will kindly give a patient hearing for 5 minutes, my lord.
5 minutes तो आप जब 5 minutes बोले थे, 5 minutes हो गया. अभी 5 minutes और आपको दे देते हैं.
हम
उसके बाद हम ऑर्डर लिखाना शुरू कर देंगे.
हम क्यों कर रहे हैं? हम क्यों कर रहे हैं?
क्योंकि आप एक शब्द भी अपना मेरिट पे बहस नहीं करते.
मेरिट पर मैं बोल रहा हूँ कि वो लोग जो क्वांटिफाई किया है, जो समन्स में, वो समन्स में माय लॉर्ड क्वांटिफाई किया, वो अमाउंट दे हैवंट टेकन इनटू अकाउंट द अमाउंट रेमिटेड बाय वी पीपल. एंड आई हैव annexed the chart that out of total 135 which is shown dues against us, 1 crore 35 lakhs, we have paid 1 crore 16 lakhs only
To whom?
to the office, to the Provident Company.
You have got all the records?
I have got the challans, I have got the records, the bank draft, some amount was realized by them by
For that matter, since you have paid, I'll ask you to go before them and show the records. reconcile the records.
Yes, yes.
But
yes.
main writ petition best करिए वो तो हम final order में ही कर देंगे.
This is what I want, my
नहीं
lords.
therefore you argue the main writ petition, whatever be the result of the writ petition. I will certainly pass an order making it very
My-
clear to the parties
I will
that so far as reconciliation of accounts is concerned, we can ask you.
This little order only I want. I don't want to waste my lord's precious time. There is no argument in this case. No. I know the law.
So that will dispose of the writ petition?
Yes, the law is well settled only for the moment, my lord, since impending Dashara is coming. And my lord, all this is not company. This is not an industry. It is not a profit-making body.
Yes.
It is affiliated college, my lord, and totally depends upon grant in aids given by the university. They are never remitted in time, grant in aid. My lord is well aware of the functioning of government.
Reason
So if
for
the-
non-remittance is not a ground for non-payment.
No, my lord, if I don't have fund, I am a beggar. When the grant in aid comes, I remit, I pay the salary after 2-3 months delay. So, therefore, my lord, they have to
An
pay.
educational institution declaring
And
itself as a
सभी
beggar.
ladies हैं, सभी girl students हैं, 4,000 हैं, जिसमें SC, ST have got the breakup. और सोचिए ये लोग देखिए, my lords, there must be some discretion exercised by them. They are exercising quasi-judicial power. They are vested with some discretion that it is not a factory, cement factory, brick factory, or company making profit. My lord, it is any way imparting education to in a backward area. Bokaro is not very advanced, and to the weaker sections of the society. So these are some human considerations. And my lord, it is a
There is
welfare.
no scope for this argument under the provisions of Employees Provident Fund. If you want to seek exemption, you have an option of exemption.
My lord,
But
I don't
whatever
want.
is the quantified amount,
My lord,
right? There are only exceptional circumstances.
yes, that is by board and all those things. That
No,
in the
even
scheme
the
itself.
board, even the board,
The scheme.
only in case of sick industry.
32A, my lords. Yes, sick industries.
And therefore, you see, this writ petition can be disposed of by saying that you get your accounts reconciled. But I will not set aside the improved judgments. I'll give you protection, you just reconcile it. Whatever payment they
Yes.
have given,
I will be,
you,
my
you
lords,
reconcile
I
it.
will be very
If
happy.
anything is left, kindly ensure that it is accounted for. See?
No issue.
Yes,
This
my
is
lord,
a
I will be very. But my lord, for some because impending.
I'll give you full protection.
My lord, the impending puja is there. Whatever meager amount, 20-25 lakhs in the account, my lords. They are not being paid salary for last 3 months. The lady teachers, their children. Just imagine their plight, my lords. There is human element in every law, my lord, the statute. It is not less, but it is just also, my lord, substance and procedure. I know fully well, I have gone through the judgments, other judgments also, that it is a beneficial, but I am just putting a question to myself. It is also beneficial to pay salary to the teachers. It will harm much more than remittance.
The attachment of your bank account
Yes,
can
yes.
be kept in abeyance for some time.
Yes. Over.
Now, it's an institution, right? It is not going to run away. It is regularly getting grants from
Yes.
UGC or university.
Only some reasonable time, my
Just-
lords.
One line solution. The orders of attachments which are under challenge by the IA, these are not related to the assessment order of the writ petition. They are separate attachment orders arising out of separate assessments. That is reflected from the period of default
Let
indicated.
us see the impugned order in the writ petition.
Yes.
And what is the period involved in the writ petition?
Yes.
Let's have a look at it.
उसी का my lord continuity है. ये
The
96 से
एक
जो.
second.
On page 32,
What is the period?
this is August 2003 to August 2012. Second paragraph, bold letters number.
August, page number 34?
32 and except 3.
30. Yes.
And the quantification is 64,48,206.
Yes.
These two
This is
figures
the
are
only
there.
figure?
Yes.
This is the only cause
Madam.
of action for the writ petition?
Yes.
Okay, let us see the order of attachment.
IA number 10199. My lord, page 20.
So there is overlapping, my lord.
Let us see.
My lord, this is it's 11 2008, that is November 2008 to June 2023.
There is some overlapping period.
Yes,
My lord,
overlapping, my lord.
that order is of 7A. My lord.
And this is what?
This is 14B.
14B. This is a separate adjudication. This is 14B order. This is a separate adjudication.
Penal damages. The reference number, my lord, JSDO Bokaro penal damages.
This is damages 14B.
My lords.
And in the second IA, page 21. Reference number is again, my lord, damages 467, page 21.
Yes. This is 14B.
This is again 14B, my lord. And in the middle of the two chart, my lord, will find same period, November 2008, June 23. So, my lord, these are related to
My lord,
different
Just,
assessments.
But the
just
topics,
7A order.
My lord, that is in the writ
ये
petition,
वाला,
page,
Annex 3.
page 32.
You see, this 7A order and this 14B order. Under 7A, you have quantified the amount. And on account of non-payment of amount quantified under section 7A, you must be raising bills on account of
Penal damages.
penal damages. Otherwise also you are supposed to issue them a notice and then the penal damages are to be levied,
Yes.
isn't it? Although it is a separate adjudication, but it is a sequel to the assessment
My lord,
made under section 7A.
only my lord, one submission for clarification, that the establishment had deposited certain principal amounts on their own belatedly and certain principal amounts upon assessment. So, my lord, the voluntary deposit with a delay, that is also covered in these, my lord, penal damages.
What they want as of now is they want reconciliation of the
Yes, I'm agreeable to that.
if this, we are seeing that it's a festival time now, they have to remit the salary to the
Let I bow down that to
persons.
that submission. Let I have no
So
objection.
the
to that.
attachment can be kept in abeyance for a month or so, such that the festival period is over, and they come with with their records, do the reconciliation, and if there is anything which they have already paid, you have not taken into account, that
will
can be taken care of.
Yes.
There should not be any problem about
No.
it. And this 14B order must have been passed after hearing them.
Yes. That is not brought on record.
actually,
This
this was
is-
my lords.
This is the notice which I had indicated in the IA, second IA. And it also contains the chart indicating the number of days of default.
You have annexed the payments made.
Yes,
Yes, they have made. They have annexed.
I have annexed. All the challans, my lords, all the bank drafts, and what my learned friend just now said, 21 of the IA. It is also an order for payment of interest number 7Q, not only 14B, my lords.
There are different heads
Yes. My
under
lords,
which they will demand money.
The route is same, my lord. The route is same. But what I feel, I don't do such cases in many numbers, my lord. But this is very harsh, and I am, my lord, reminded of
Then
double
you-
jeopardy. Double jeopardy.
Then you challenge it by a declaration that it is ultra vires. Unless a law is declared ultra vires, this court
No,
will
no.
not say it is harsh.
It was coming to my mind, my lord, that
It is
interest
not
on one
harsh,
hand.
sir. Please appreciate.
And
It is not
damages
asked-
penalty 22 of the Constitution, my lord.
that it has been challenged and it has been upheld by the Honorable Supreme Court.
That's
It has been challenged by and upheld, and the reason for non-payment,
My lord.
right? Even that challenge has been taken care of. Now, after the judgment of Dharmendra Textile, which I have discussed here, there
This
is a
is a
judgment
recent
of the Honorable
judgment.
Supreme Court.
I just want to know, because recent judgment, this virus was challenged in a recent judgment or
No, long back.
no?
1979. organochemicals.
1979, long back.
My lord, I am
And
reminded.
the reason for this sustaining this particular kind of a
Ma'am.
linkage, they say that this is a kind of this amount you have retained and used it, so therefore it has to be paid with interest. 100 rupees, which was due in 1980, is not equivalent to 100 rupees being paid today. So it is basically compensatory in terms of interest. So that should be sufficient.
My lord.
If there is anything you have not accounted for, you account for it, and
They will come with their records, whatever they have.
yes,
And they should also, my lord, provide the records.
they will. They
Yes, our
have given the
records
records.
are
The
only
remittances
dependent
which
You
upon
are
them.
asking too much. Whatever you have remitted, they will take care of. And so far as other prayers are concerned, you don't want to pray. Are you sure?
Yes. No, my lord, that is academic only, my lord. This is
Is
the
it
crux.
academic? 7A order, is it academic?
No. Order, my lord. This order, impugned order.
Yes.
Yes. The impugned order is still that one is attachment, my lord, and one that, my lord, वो तो जुट गया 64 करोड़ इसमें जुट गया, हम पेमेंट भी करते हैं 64 लाख. अब वो सारा हुआ क्या है, वो जमा होते होते इसमें आ गया. तो अब ये थोड़ा सा हमको आई मीन फिक्स माय लॉर्ड्स में कीप इट
देखिए
पेंडिंग.
हम आपको बताते हैं आपके इंटरेस्ट की बात. He has a remedy under law. Tribunal is functioning. He can avail his remedy. He can have an interim order from the tribunal. And so far as attachment is concerned, we are going to stay for some time. And this remedy he can avail. इनको नॉन सूट इनको नहीं समझ आ रहा. ये मूलधन रह जाएगा तो इंटरेस्ट खत्म होगा कभी.
कभी.
फिर
तो हमको लिबर्टी दे दिया जाए.
आप
यदि माय लॉर्ड्स,
देखिए हम आपको बता रहे हैं आपका
no, my lord is correct. I know I am trying to appreciate, but my lord, I haven't gone through meticulously the writ, and it is very old matter. And presently, what is pinching my lord in the shoe, my lord, that is this attachment, my lord. They approached me only, my lord, 10-15 days back. The principal is also ill, sick.
ये देखिए आपका ये
हमको
The
लिबर्टी
assessment
हमको
order
लिबर्टी दे
also,
दिया.
my lords, the assessment order speaks that the establishment accepted the default in the proceeding. The
Therefore we
principal
have paid.
appeared on 20 June 2014 and 8 August 2014 on behalf of the establishment, and when asked about the correctness of the amount and date payment shown in Annexure A, he raised no objection and confirmed the correctness of the same.
Now this was, my lord, earlier principle. Of course, it is not going to make much difference. Now there is a new principle, my lord. They did not hand over the record. The accountant is new. So all these bottlenecks came in between, my lords. And it is for this reason that we are making payment, my lord. हम लोग 1
The
करोड़
establishment
16 लाख
had
दे दिए.
stated that PF and allied dues had not been remitted in timely due to financial difficulties.
that is not a ground.
That is not reflected from the order impugned in
And
the
we have
writ.
annexed all the grants when we have received in the return, the rejoinder, etc.
मेस कर दिए हैं सर हम लोग को
हाँ, mess
इंस्टीट्यूशन
तो-
मेस हो गया.
Therefore, my lord, I am praying that I may be granted temporary relief and I may be granted liberty to move the tribunal. What else I can do, my lords?
ट्रिब्यूनल जाने दीजिए अपना कुछ एक्सप्लेन करना चाहते हैं. All the points will be left open to the parties. I will not say that it
My
will
lord,
be decided on
this
merits.
objection of, I
This-
will only indicate for my lord's appreciation this aspect. Our own division bench, sitting in appeal, has now held and it has been upheld up to Supreme Court that the period of limitation cannot be beyond 120 days.
ओ ये भी तो उसने कहा।
That also
लेकिन ये
goes.
तो यहाँ पे टाइम से फाइल कर दिया
हाँ, he can avail, my lord, he will invoke section 14.
is always there.
Section 14.
You see, when did he file it? Over here. वो तो हम थे ना उस डिवीजन बेंच में।
My lord will kindly see.
Yes, yes, we are aware of this.
It's just like commercial appeal, very strict.
Then we can say that they will avail their remedy as may be permissible under
Yes,
law.
that
Nothing
will
beyond,
suffice.
right? And so far as this attachment etc. is
That
concerned,
can be stayed for some time.
That can be
till the
stayed for
recon-
some time.
But they may not, my lord, misuse this liberty by
No.
delaying in reconciliation.
इंस्टीट्यूशन थोड़ी बंद हो जाएगा।
नहीं, अब एक महीना गुजर, अगर ये लास्ट दिन 30वें दिन आएंगे हमारे पास,
नहीं, हम तो बोलेंगे कि आफ्टर आई जस्ट फिक्स अ डेट आल्सो। आप बताइए कब जाइएगा अपना रिकॉर्ड सब। ऐसे थोड़ी हम यहाँ से ऑर्डर
Before
करते
the officer, my lord.
हैं। यस, चूज अ डेट।
Not,
बताइए,
I will be granted after 15 days, 20 days.
आप बताइए,
Reasonable time.
बताइए रीजनेबल टाइम आपको बता दें। 14 अक्टूबर को चले जाइए। 14-10
मतलब since दशहरा छठी सब थोड़ा सा टाइम।
और बताइए फिर 15, 17, 17 reconciliation will take by 29th it can be done.
my lord, sufficient. 29th.
29th October.
हाँ yes, 14-15 days will suffice for us.
ठीक है. And then you will give them the result of reconciliation only. That can be given by 14th of November.
Yes.
And the order of attachment of the bank account will be kept in abeyance till 18th. Okay? You have students in your school?
November, my lord.
How many students do you have?
4,000, 38, 39. I have given the figure in the, and I have got the chart. I got all the chart from them, my lords.
You get financial aid from which?
From university.
From
See,
university.
Yes, this is
Vinod Bihari.
Vinod
From the
Bihari.
concerned university, right?
Affiliated. It is affiliated. It is not constituent.
Vicky.
Not degree, but all
Yes.
streams.
So you are concerned with these two IAs, right?
Yes, yes. Very correct, my lords.
WPL number 6310 of 2015 with IA number 10199 of 2024 and IA number 10518 of 2024. The learned this petition has been filed for the following relief. So far as IA number, the prayer made in IA number 10199 of 24 is as follows, and prayer made in IA number 10518 of 24 is also quoted as. The learned counsel for the petitioner has submitted that initially the petition was filed on 20/12/2015 alleging that the impugned action and orders taken by respondent number 3 was wholly without jurisdiction. He further submits that the order passed under section 7 capital A read with section 14B and 7Q of Employees Provident Fund and Miscellaneous Provisions Act and Miscellaneous Act 1952 was challenged, and the writ petition remained pending before this court. During the pendency of this writ petition, some more orders have been passed which are essentially sequel to the impugned order and arise out of assessment made under section 7 capital A. And those adjudications are, those orders are for period which is overlapping, which is substantially overlapping with the period involved in 7A adjudication and impugned in the main petition.
There are certain amounts which have been calculated separately under 14B in absence of 7A, because that was delayed the remittance by them.
That's it. I will record your submissions. The learned counsel further submits that the bank account of the petitioner has been attached for realization of sum of rupees 1,34,00,01259 and the petitioner is a college having around 4,000 students. I'm recording it. Having around 4,000 students.
Maybe some less.
More than 3,000 students.
No, 3,500.
More than 3,500
Yes, I
students.
mentioned it.
And is getting funds from the concerned university. He submits that on account of this festive season, the salary of the teaching and non-teaching staff is to be paid, and as the bank account has been attached, the petitioner is not in a position to make payment. The learned counsel has also submitted that as per the records of the petitioner has made huge payment against the Provident Fund dues amounting to tune of rupees
1,16,00,000
1,16,94,683.
94,683.
He submits that if the date of remittance by the petitioner is taken into consideration and is adjusted at the concerned date on which the payment has been made, the liability on account of damages by way of interest and liability on account of non-payment of the amount arising out of proceeding under section 7A would itself substantially reduce, and he submits that the payment made by the petitioner has not been properly accounted for, correct? Has
Yes.
not been properly
And
accounted
written letters
for
also.
by the respondents. The learned counsel submits that the petitioner is ready to approach the respondent number. Who would be the respondent?
He may be included as a party also.
necessary.
पता है किसको? To the
The
Regional Provident Fund Commissioner.
who will do it?
APFC, Assistant Provident Fund Commissioner Dhanbad.
Assistant Provident Fund Commissioner धनबाद.
DO Bokaro.
वो नहीं ना करेंगे. आप किसके अंडर में आप?
Dhanbad.
Assistant Provident Fund Commissioner धनबाद.
Under Regional Office Ranchi.
Under Regional Office Ranchi. The Learned Council submits that the point regarding that in view of the counter affidavits filed in the present case, he does not want to press the point regarding jurisdiction of respondent number 3 with respect to the impugned order dated 1/7/2015. But right may be reserved with the petitioner to avail his remedies as may be permissible under law. Okay?
Limitation if any.
नहीं कर सकते हम पावर नहीं.
Removing the tribunal.
वो आप जानिए क्या? When you want to reconcile the accounts,
No, since we were here, my lord, the matter was paid sub judice.
वो आप अपना जानिए क्या?
जो तब तो वो यदि रिजेक्ट कर देंगे तो
वो नहीं रिजेक्ट करेंगे. सेक्शन 14 अप्लाई करेगा नहीं करेगा भी नहीं. 20/12/2015 से यहाँ पेंडिंग है.
ये लेटेस्ट ऑर्डर तो हाल का है तो इसको तो आईए वाला तो रिसेंट है, अगस्त में निकाले अटैचमेंट ये सब.
अटैचमेंट के अगेंस्ट में थोड़ी आप वहाँ जा सकते
या ये जो समझ दिए
हैं. अब
वो
बीच में नहीं
असेसमेंट
डिस्टर्ब करिए, इससे ज़्यादा हम नहीं बोल पाएंगे. The Learned Council has also submitted that summons have been issued
that is in another IA, my lord. IA 10518 at page 21 and 41, two summons. No, page
summons for production of records,
21 and 43.
summons for
14B
Appearance,
proceedings.
my lord.
14B proceedings.
summons have been issued
One is dated 26/8/20
dated 21/6/23 and
26/8/2020. That is annexure 18 of the act. ये उसी
page number
43.
page number.
Yes, 43/49 of IA 10518.
Summons has been issued to the petitioner for quantification of damages under section 14 capital B, which are under challenge in IA number 10518 of 2020.
Minus.
The Learned Council submits that the petitioner would appear before the authority on 17th and appropriate time frame may be given so that the accounts are reconciled. The Learned Council, appearing on behalf of the respondent, has submitted that there can be no problem in reconciling the accounts, but there is stringent provision for condonation of delay if the petitioner challenges the impugned order in the writ petition before the learned tribunal. However, he submits that the petitioner may avail his remedies in accordance with law. He has also submitted that not only the order under section 7 capital A of Employees Provident Fund and Miscellaneous Provisions Act, but also other provisions are also amenable to the jurisdiction of the learned tribunal. Right?
Not separate, not separate.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that initially the petition was filed challenging the jurisdiction of respondent number 3 to pass orders and take action against the petitioner. But during the course of hearing, the petitioner, the learned counsel for the petitioner, has given up the said challenge.
Madam, there were twofold, sorry, my lord. In the writ petition, what was the jurisdiction? And one, my lord, for waiving the damages, 64 lakhs. Twofold prayers,
Further prayer was also made
my lords.
seeking waiver, seeking to dispose of the application under section 14B, read with section 32B of the Aforesaid Act for waiver of damages.
This one, please,
which was said to have been filed before the Central Provident Fund Commissioner Central Board meeting. थर्टी टू बी में तो आपका आता ही नहीं है,
Pardon?
32B में आपका वेवर का मैटर नहीं आता. Anyways,
लेकिन तब इसमें भी
Just-
डिस्क्रिप्शन है मैडम, डैमेजेस में they have got discretion in quantifying the damages penalty. Frequently. उसमें 32 Sikh industries.
इन्होंने जो आपके पास फाइल किया एप्लीकेशन उसका आप डिस्पोजल कर दीजिए सेंट्रल बोर्ड को.
With respect to waiver,
यस जो भी है jurisdiction है नहीं है. It appears that the application of waiver under section 32B was filed, and during the pendency of the application, the present writ petition has been filed. Without commenting upon the maintainability of the claim for waiver and entitlement of claim for waiver by the petitioner, this court directs the central board to dispose of the petition for waiver within a period of 2 months from the date of communication of this matter. The petition for waiver has been annexed as Annexure 7 to the present writ petition. So far as the adjudication and demand raised under the various provisions of the Aforesaid Act of 1952 is concerned, the petitioner has efficacious, this court is not since the petitioner has given up the point of jurisdiction, this court is not inclined to exercise power under Article 226 of the Constitution of India to adjudicate such issues as they involve disputed questions of facts. The petitioner may avail the remedy as may be available under law. Considering the grievance of the petitioner regarding reconciliation of the amount which has been paid by the petitioner and the attachment of bank account of the petitioner is concerned, and also considering the fact that the petitioner is an educational institution who has to remit wages to teaching and non-teaching staff, this court directs the petitioner to approach the respondent number 3,
Yes.
respondent number 3 with all details regarding payment against the Provident Fund dues on 17th of October 2024, and upon their appearance, the respondent number 3 shall do the needful and grant an opportunity of hearing to the petitioner and reconcile the payments made and the demand raised by 29th of October 2024 and communicate the decision by the first week of November 2024 through the email which may be provided by the petitioner to the said client. Considering the totality of facts and circumstances of this case, the order of attachment of bank account shall be kept in abeyance till 14th of November 2024.
Lecture 14 may kindly be indicated. Lecture 14.
Lecture 14 is what?
The date will be 12/8/24 का.
Sorry?
Date of attachment, it may kindly be indicated. This is 12/8/2024. This is page 20 of my IA numbers.
20.
IA number 10199.
As contained in Annexure 14 to IA number
10199 of 20.
10199 of 2024,
Right.
which is dated 12/8/2024.
Yes.
In case the demand is revised by virtue of reconciliation, it will be open to the respondents to take steps, क्योंकि फिर अटैचमेंट ऑर्डर खत्म हो जाएगा कमेटी, और अगर यही रह जाता है तो फिर रिवाइज, और ये बोर्ड भी by should decide it by 14th of November.
I was going to submit in that respect. In my counter to that paragraph 18 of the writ petition, whereby Annexure 7, the representation is closed, I have stated that the application for waiver of damages is misconceived and not maintainable in para 60,
But they will have to pass it.
and that is addressed to the CPFs, Central Provident Fund Commissioner.
किसको जाना था, बोर्ड ही को जाना था.
The board is a
a
collective
separate
body,
body.
but the CPFC will not normally is the chief executive officer who communicates the decision.
इसमें जो ये annexure 7 वाला है ना, इसमें लिखिएगा the learned counsel for the respondents has submitted that the application for waiver has been made is addressed to Central Provident Fund Commissioner Central Board, who is not the appropriate authority to consider the application. He has also submitted that otherwise also the application for waiver is not needed. The application for waiver has to be filed before the central board, and the waiver is only for the purposes of under section 32 capital B, and the waiver is only for the purposes of section 14 capital B of the Act of 1952. This board will not act through this Central Provident Fund Commissioner Central Board. Who is this authority?
It's a misnomer. The nomenclature is not properly given by the petitioner. Central Provident Fund Commissioner. There are numerous Central Provident Fund Commissioners in the headquarters.
Considering the aforesaid facts and circumstances, the petitioner may approach the Central Board by filing appropriate petition.
But Central Board, my lord, that is
Central Board नहीं होगा.
cooperatives and Sikh industries. I don't think it will.
It is not maintainable. I know that it is not maintainable. अब आप ऐसा कहानी सुना रहे हैं तो हम क्या ही कर सकते हैं? It is not maintainable. एक मिनट में हटा देंगे.
छोड़ दिया जाए
इसको छोड़ ही दीजिए.
नहीं.
I will not
my
mention
lord,
about
our
this.
role is to properly assist this one.
सिर्फ
हम
Sikh industry.
जा ही नहीं सकते हैं. अब न
That
सिख
the-
है न कोऑपरेटिव है न कुछ. कोऑपरेटिव कॉलेज भी रहते जमशेदपुर जैसा तो चले जाते. नेम सिख.
ट्रिब्यूनल की कुछ पावर है.
Tribunal will decide everything.
Right.
Yes.
तो ये वाला छोड़ देते हैं. सेंट्रल इसका जिक्र पूरा ही छोड़ देते
Yes.
हैं. टोटल.
No need.
ठीक है. चलो.
And for
My lord, lastly, a liberty may be granted.
What liberty हो गया? अब इतना देर तो क्या इसमें कुछ नहीं है आपका.
नहीं,
गलत जगह पे गलत प्ली पे फाइल कर दिया. आपका इंस्टीट्यूशन है, so I have all
My lord, I am
certificate.
happy that such a carcinoma case has been disposed of. Carcinoma, and
My lord,
he has
the-
also been relieved of the burden.
देखिए आपको हम तो एडवाइस करने वाले नहीं हैं, लेकिन यू शुड फाइल योर पिटिशन बिफोर द ट्राइब्यूनल विद इन टाइम. और यहाँ पे इतना दिन से पेंडिंग है, हमको नहीं लगता कि टाइम बाद हो जाएगा. सेक्शन 14 का एप्लीकेशन लगा के.
I will abide by my lord's directions.
नहीं, not my direction.
No.
I'm just telling you.
Observation.
I'm showing you the way by which you can get
Yes.
some relief.
My lord, one more submission. My lords have remanded it to the respondent number 3
Yes.
for reconciliation. My lord, may
One
indicate the APFC concerned of the area, because after realignment of the officers, my lord,
Assistant Provident Fund Commissioner of the concerned area in which the institution of the petitioner is located. ठीक है? कर लीजिए, कुछ होता है तो कर दीजिए भाई. इंस्टीट्यूशन बंद हो जाएगा. Do something about it.
Oblige.
आइए डिस्पोज ऑफ.
My lord's one prayer. A copy may be handed over. There is some sense of urgency. A copy of this order, my lords. It may be.
It will be immediately uploaded, maybe by tomorrow.
Yeah.
कल के पहले नहीं होगा सर, इतना स्पीड हमको नहीं है.
नहीं.
आने से होगा सर.
एक दो दिन में हो जाए.
हो जाएगा.
Sometimes
कल
server
ये
reports
इम्पोर्टेंट ऑर्डर है, हो जाएगा.
Item 1, passover case item 1, WPL 499 of 2009.
Yes, petitioner.
this matter.
You're seeking time.
इसमें डिफिकल्टी एक आ गया है जो मैं बताना चाह रहा हूँ. इसमें आई हैव ऑन द लास्ट ओकेजन ऑल्सो मैंने समय इसमें दिया था कि टू एग्जामिन द वेयरअबाउट्स ऑफ द रिस्पोंडेंट वर्कमैन, क्योंकि ये यूनियन की तरफ से फाइल हुआ था, कोई टच नहीं मिल पा रहा है.
वकालतनामा है ना आपका, बस
सरकार
उतना ही टच बहुत है. आपको वो वर्कमैन क्या करेगा, रिकॉर्ड है, आप बहस करिए.
इसमें ये अपॉइंटमेंट का मैटर है, वेदर ही इज अलाइव और नॉट.
We will not assume that somebody has died. There is no such assumption in law. There is a presumption that he is alive, right? Unless he has already attained 100 years. I assume that a person will be alive till 100 years. These are not the grounds.
इसको
Don't wait for the workman to die.
नहीं
Let him
तो
have the fruits.
इसको तो सिंपली
कुछ नहीं, आपको टाइम लेने के लिए इतना बहाना आप लोग बनाते हैं ना कि हम परेशान हो गए टाइम से. The award was stayed.
Yes.
So 17B was being paid.
19 week it is for the was not a workman because he was to get appointment against a particular scheme. And that scheme he did not avail. Now the prayer is for appointment on compassionate ground. And there is no scheme for compassionate appointment in the.
सुनिए ना, इसीलिए आप टाइम.
So our precise point is
चलिए बहस करिए.
award is at page 41.
हाँ, पढ़िए award का.
And the operative
Let
person
us see the reference.
is 51 page. Award is at
Oh, this is compassionate appointment
यस
without a scheme.
there is a scheme that is known as the dependent employment scheme. If the particular employee has already completed minimum 15 years of service, then he is entitled to get his award name registered in the dependent employee scheme.
So which company?
just go.
But that was not availed of in this particular case. And then, at the time of conciliation, the offer was given that even now, if you want to get your name registered in that particular employment dependent scheme, then that can be done subject to the consent of the particular approval of the particular committee. That was also not agreed to by the union. And then, therefore, the matter was contested finally, and the operative portion of the award body had phase 3.
There is a direction to give him appointment,
Direction for compassionate appointment.
compassionate appointment to the son.
Yes. Now our ground is that in the absence of a scheme for compassionate appointment, there is no scheme. The only scheme is dependent employment.
His
that has not
father-
been- and on that, in the absence of a scheme,
Ashok Kumar is the person, right?
yes,
Dependent. The father is alive or dead?
he died.
He has died.
He has died when?
1994.
Long back. So he was seeking compassionate appointment
But he also
on account of his death.
Death of his wife.
Okay.
and the very purpose of the compensation appointment after that lapse of 31 years, that is also not.
When did he die? Death बताइए. There is no scheme. Yes, tell us. What is there? There is no scheme. Tell us.
I am placing reliance on the judgment of the Honorable Supreme Court reported in 2011, volume 4 SCC.
Thus, then, in just this view of the matter, if my senior friend is submitting that if there is no scheme, so the matter may be disposed of, giving liberty to the workman to apply afresh in future if any scheme comes.
Apply afresh.
एक रास्ता कम से कम खुला रहेगा.
क्या रास्ता खुलेगा?
31 years हो गया उसका. 31 years.
उसका रास्ता बंद, मेरा सबमिशन यही होगा कि कंप्लीट रास्ता बंद होने से अच्छा है कि वो कोई रिप्रेजेंटेशन दे देते वहाँ.
अवार्ड में क्या रिप्रेजेंटेशन का हम ऑर्डर करेंगे? आप ही बताइए. या तो अवार्ड आप होल्ड करेंगे या अवार्ड सेट असाइड करेंगे. there any possibility of giving any order of representation? 226 का read पैसा नहीं? Please. What is the reason for giving such an award? What is the reason for giving such an award? Please read it. Finding.
Turn to page number 47. The award, para 10.
Para 10. Yes.
London Council for the Workman. For FIR, FLR, 1992, 64, page 990, which Honorable Allahabad High Court held that the appointment of an incumbent or contested appointment in the light of recent law as well as the government orders. So there is no order of the scheme gets the top priority. At present, it has come to the extent of creation of new post. The council also referred to judgment reported in 1999-83 FLR to 1929, on which Honorable High Court let down that Section 2A and 10 of the Industrial Disputes Act, between an employer and his workman, which is connected with the non-employment of any person, can be an industrial dispute. Industrial dispute. Beneficiary of claim will not be a workman of the employer. So that is how the issue involved here. Entitlement to be an appointment on the compassionate grounds. Industrial dispute that can be referred for adjudication. And finally, accordingly, I rendered the following award. The action of the management of the DISCO in denial to provide employment to the Ashok Kumar, son of late Ganesh Prasad, is not justified. Hence, the management is directed to provide employment to Ashok Kumar, dependent son of late Ganesh Prasad, within 2 months from the date of the public assembly award. So, in the absence of the scheme, the question of providing direct employment does not arise. And apart from that, under the scheme for the dependent employee, there is a long list, and that according to the seniority, the appointment is given as and when the vacancy arises, subject to certain
That
tests.
is not a compassionate appointment. That is just a dependent appointment. Is it a compassionate appointment?
That is scheme they have not availed of.
That
Yes,
scheme they have not availed.
So now it is a purely compassionate appointment without a scheme. And I am
Without availing the scheme.
I am relying on the decision of the Honorable Supreme Court, reported in 2011 SCC, page 206, at page 214, para 20. Which reads, thus while considering the claim for employment on compassionate ground, the following factors have to be proven in mind. Compassionate employment cannot be made in the absence of rules or regulations issued by the government or a public authority. The request is to be considered strictly in accordance with the governing scheme, and no direction as such is left with any authority to make compassionate appointment the host scheme. So
His father had applied for enlisting his name, but thereafter he died. That is the finding. You come to para number 6.
But the question is, there is no finding that there is a scheme in existence for compassionate. And the scheme is referring to the
It
dependents.
is your case only that there is a scheme in which the name of such persons are enlisted.
That is a scheme, not a compassionate scheme. But that is dependent on the length of service of a particular employee and there is a seniority list in that. And thereafter, if his turn comes as and when the vacancy arises, then he has to undergo certain tests that we have filed.
You read para number 6.
वो affidavit हम लोग file
You read para, वो affidavits नहीं होगा, para 6 पढ़िए. Para 6 पढ़िए. You read para 6 of the award. Read it, please.
Yes. Just a minute. That it is submitted that the present reference is not so award.
Yes, read it.
Just a minute. Some time.
You see, as per this, आपके पास नहीं है फाइल. Para 6 पढ़िए. Read para 6.
The main argument on behalf
That
of the
the-
management is that name of Ashok Kumar has not been mentioned by his father in the employee dependence register. In this respect, the learned counsel for the workman argued that he has given his application for employment of his son Ashok Kumar for registering in the employee's dependent register as per Exhibit W3, which has been proved by Ashok Kumar, WW1. The concerned workman's father, late father, filed application for registering the name of his son so such and such for employment. It is up to the management who registers it or not. The management has not produced register of dependent employment so that it can be gathered that the register has been properly maintained or not. In this respect, the MW1 has stated in his cross that he has not filed any paper to show number of dependents waiting for employment. It only shows that management always hide and seek the employee dependent register so that it can discourage of any merit as per document admission. Late Ganesh Prasad has completed 15 years of service and died due to TB as per Exhibit W1. It has been admitted that Ashok Kumar's father died after putting 15 years of service and died due to TB, and it was agreed by the management before ALC that employment be given to Ashok Kumar, but it has not been done. Moreover, in the written statement, it has been admitted by management in parallel that concerned person may submit his mercy petition and his name may be enrolled if joint decision can be made by management and recognized union RCNS as a special case, and his case may be considered for his employment against future vacancies along with eligible candidates. It shows that the concerned workman late father gave application for registering the name of his son in employed it and registered died due to TB after putting 15 years of service, and management has considered and assured for his employment as per para 12 of the written statement and Exhibit W2 conciliation proceeding but it has not been done by the management for the reason best known to them.
You see, para 12 of the written statement was that he can file his mercy petition and his case will be considered along with the other against future vacancies, right? So a direction to give compassionate appointment has to be, that has to be followed as per the scheme. So at best, the direction could be to put his name in the register.
वही हो
It
सकता
could not be, there cannot be, a priority given to him without
There can't-
considering others.
Yes, Your Lordship. There are several judgments on this point that without, in absence of scheme, there can't be any blanket order for providing
Yes.
employment. तो इसको वही कर दिया जाए, अवार्ड मॉडिफाई करके वही कर दिया
इतना कर देते हैं सर।
जाए, सिंपली मॉडिफाई तब अवार्ड कर दिया जाए.
इसमें we have filed detailed affidavit on all these aspects.
No, we can't see anything which was not filed before the court. You see, he completed 15 years of service. He gave an application, and subsequently you also asked him that you can give an application, and ultimately that was not given. Then the court would have only directed that his case will be considered as his case be registered, put in the register, and as per the seniority it will be considered
Under that particular scheme,
under that particular scheme.
that is the case.
That is it. तो उतना modify करने से हो जाएगा.
बस वो इतना कर लिया जाए.
As per their own
Yes, ये
scheme.
जो दिया हुआ है यहाँ की
Right?
पैरा नंबर सच एंड सच ऑफ WS.
ठीक.
The only point is now that 31 years have left.
देखिए ऑर्डर को कोई अवार्ड को इतना लाइटली नहीं सेट असाइड कर सकते. WPL number 499 of 2009. Third, the Learned Council for the parties. The Learned Council for the petitioner submits that the Learned Tribunal has directed the management to provide employment to Ashok Kumar, son of late Ganesh Prasad, as dependent son of the ex-employee Ganesh Prasad. He submits that there is no scheme for giving compassionate appointment. However, it has come in the award that the petitioner maintains a register for the dependents of the employees, and at best the Learned Tribunal could have directed to put the name of Ashok Kumar in that register, whose employment could be considered along with others depending upon future vacancies.
As and when the vacancy is.
As and when the vacancy arises, and
Subject to
the
other qualifications.
management was required to consider the case of Ashok Kumar as per their existing policies. Right? The Learned Council, appearing on behalf of the respondent workman, has referred to paragraph 6 of the impugned award and submits that appropriate order may be passed so that the name of Ashok Kumar be placed in the register and his case be considered as against future vacancy as per the scheme of the petitioner. Correct?
As per the para 12 of the WS which was filed by the management, it has come in page number 46.
He has submitted that in paragraph 12 of the written statement filed by the management. They had stated that the concerned person would submit his mercy petition and his name will be enrolled in the, if the joint decision can be made by the management and the recognized union as a special case. ठीक है?
15 years उसके नीचे वाला पैरा लिखवा दिया 15 साल सर्विस लिखवा
He has also submitted that it is not in dispute that the father of Ashok Kumar was an employee of the petitioner and he had completed 15 years of service and the condition precedent for his entry in the register was duly satisfied.
and as per para 12 it was admitted by the management to put my name in the register but the same has not been done by the management.
Admitted matlab kya? So that is why the litigation was there. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that the terms of reference was as follows. It appears that the learned tribunal directed the petitioner to provide employment to Ashok Kumar, dependent son of late Ganesh Prasad within a period of 2 months from the date of publication of the award. However, as per the discussions made in paragraph 6 of the impugned award, it is clear that as per the scheme of the management, a register is to be maintained for the purposes of maintaining the list of dependents of the workman,
Employee dependent register.
employee, which is known as employee dependent register, and the cases are taken up against future vacancies along with other eligible candidates. There is no material on record to show that there was any scheme for compassionate appointment in the management. Accordingly, this court is of the considered view that the learned presiding officer could have at best directed for putting the name of Ashok Kumar in the said register instead of directing giving appointment to Ashok Kumar. The learned counsel appearing on behalf of the respondent has also agreed to the aforesaid modification in connection with the operative portion of the award, and accordingly the award is hereby modified, directing the petitioner to enter the name of Ashok Kumar in the dependent register upon an application filed by Ashok,
My lord, here by submission.
and his case be considered as per the scheme of the
And the existing norms as per the existing norms of
And the
the
existing.
management.
Here my submission is that we have filed a supplementary affidavit on 21/3/2023.
क्या supplement?
इसमें नहीं, इसमें वो लिखा हुआ है conciliation में जो decided that it is jointly agreed by the committee that name will be entered, but thereafter the union declined it. That affidavit we have
इतना
already
नहीं हो
filed.
सकता, इतना हम अवार्ड को मॉडिफाई नहीं कर सकते.
मैं तो इसलिए हम
As per paragraph 6 only, it is mentioned that you will enter his name if he files a mercy
as
petition.
per this
Yes. If he comes, the respondent, the what's the respondent workman है?
Yes. ये
The
respondent
respondent
यहाँ
क्या
union
नाम है? Workman नहीं.
हाँ
respondent
हाँ
कौन होगा
उसको
ये?
एक डायरेक्शन दे दिया जाए कि 1 महीना के अंदर
नहीं एक second. The needful be done by Ashok Kumar within a period of 1 month from today. 1 month. 1 month
1 month from today.
from the date of communication of this order to the concerned. Let this order be communicated to the cabinet. थोड़ा टाइम लगेगा ना साइन होने में जाने में. 1 महीना from the date of communication.
IAS भी pending था मैं देख
Which IA?
कुछ
Pending IA closed.
already stated
Interim order vacated.
सारा ये
और क्या क्या चीज का IA फाइल किया हमने?
और कोई पेंडिंग नहीं है स्टे मिला था
वो तो
Last
स्टे
stay-
मिल ही गया. Interim
last
order
stay-
vacated.
last stay was granted 16/11/2009 until further orders.
IA close कर
IA pending IA is closed. आपके यहाँ तो स्कीम है, सबको पता है. सबको वैसे भी पता है, स्कीम तो है ही.
ये स्कीम है लेकिन इट इज नॉट ए कंपैशनेट एफर्ट.
नहीं कॉम्पैशनेट नहीं, डिपेंडेंट का एक लिस्ट रखते हैं, उसको कंसिडर करते हैं जब भी कंसिडर करते
But that cannot be said to be a scheme for the compassionate.
हैं. नहीं, it is not a scheme for
That
that.
is our
That I have already held that there is no scheme for compassion.
that reference can
dependent
be-
employees dependent का वो
Register.
employees dependent
Paso case item 3, WPS 7796 of 2012.
मंडे को रख दिया जाता है इसमें LCR आ गया ऑटोमेटिक इससे बोनस LCR
क्या है ये?
ये reinstatement along with full back pages
So you're wanting full back pages?
नहीं हम तो वर्कमैन को हो गया है वी आर ऑन बिहाफ ऑफ द फूड कॉर्पोरेशन ऑफ इंडिया द मैनेजमेंट
Yes.
ऐसा इसमें
Yes, madam.
ज़्यादा तैयारी का सर
Okay. Yes, madam.
यूथ हो गया है
I can't hear you. I can't hear you. क्या अवार्ड है जो इतना आपको तैयारी का जरूरत है?
reinstatement as well as regularization दोनों करने का ऑर्डर कर दिया है और सेटल बोथ कांट बी in view of that अखिलेश कुमार खरे's judgment
हम नहीं जानते judgment
ये तो नहीं और सब आप written notes बना दो because if a contract of employment is not existing there can't be any regularization.
So therefore, they must have held that the discontinuation is bad in law. Possible?
Yes, it has been made that the retrenchment is bad in law.
दोनों पॉइंट पे रेफरेंस रेफरेंस तो आंसर करना ही पड़ेगा. The point, the reference was on both the points. 25F का violation.
जी
क्या बोलना है?
इसको मानिए
BSNL वाला जजमेंट है? लाए हैं नहीं लाए हैं? वो हम ही बताएंगे. I think BSNL का जजमेंट है. 25F में the discontinuation is held to be bad. That does not mean that automatically entire back wages is to be paid. हम लोग DB में कई सारे ऑर्डर्स किए हैं इस पर.
yes that PSM has because my senior had argued that yes, and I remember
Yes, madam, I can't hear you. Are you in Ranchi?
yes she's in
Madam,
Ranchi
Ranchi में? We can't hear. कैसे होगा?
that has been muted she unmutes
Madam, you need to unmute yourself. Unka. There is some problem in connectivity. Call her and find her out when she can come. Because we can't hear her. If she is here, she can come on Monday. Or छोटा सा मैटर है, क्यों इतना आप लोग परेशान रहते हैं?
इसको रखवाए थे तो मैंने
BSNL वाला जजमेंट आप उनको भी प्रोवाइड करेंगे, ऐसे हम लोग नहीं कर सकते, राइट? तो याद है BSNL वाला ही जजमेंट, लमसम कॉम्पेंसेशन हम लोग फिक्स करते हैं।
Yes, I had just joined practice on at that time when university में class that और याद आ गया।
याद आ गया। Madam, we can't hear you. पूछिए कब आएंगे? Counsel for the parties are present.
17 भी मिल रहा है तो उसको 17 मिलों तो ऑलरेडी मिल रहा है तो इसको कर ही नहीं।
Mrs. Manimala Pal has joined online on account of poor connectivity. The matter cannot be heard. बताइए कब? अभी आपकी आवाज आ गई, हमारी तरफ से गड़बड़ था ना? Yes, madam. Yes. Madam, you are fighting for similar matter has been decided.
Similar matter has also, yes, madam, but the Honorable Supreme Court division bench has also the one of those that I have given the judgment to my junior.
Where is that judgment?
Yes.
Other side को नहीं देंगे?
Yes.
So this judgment is in your favor? Is it in your favor, madam?
And other side, that is going on the other side. That is 231. Yes, madam. All the judgment in my favor of that is under the scheme and the judgment and regularization.
Perhaps
Under the same scheme.
she is referring to that Harinandan's case.
It has rightly raised by the Honorable Supreme Court also, they are entitled for the all benefits. And the benefit of the scheme of 1997 and several similarly situated persons have already been regularized under the scheme. Those who have completed 90 days on 5-17.
Because that is the judgment which she is referring is of Harinandan's case in Harinandan's versus Food Corporation. उसमें था कि जो कट ऑफ डेट जिस दिन हुआ उस दिन जो लोग काम कर रहे थे उन लोगों को मिलेगा और जो कट ऑफ डेट के पहले नहीं थे उन लोगों को नहीं मिलेगा।
तो ये they are after the cut off date.
इसमें था
देख
चेक कर लेंगे अगर उस डेट में थे तो ब्लैंकेट वही ऑर्डर हो जाएगा।
Yes, madam. You were there is a cut-off date in Harinandan Prasad's judgment. Is there a cut-off date? Yes. There is a cut-off date in this judgment. That is 4/5/1990. That is
under the scheme, those who have completed 90 days as on 2/8/26.
2/8/26. No, it is
4/5.
just
90 days completed on 2/5/86 and the scheme is 6/5/87.
scheme is 6/5/87. Grievance other similar who had rendered 240 days were regularized as per the scheme dated 6/5/87. Okay. So you had completed 240 days as on 6/5/87.
Move खाली 50 से 90 days. That is the scheme.
240 days.
67. No. So 90 days. It is 90 days.
Okay. Then by this judgment for 240 days also it was.
1987 came up to court that is, there is a breach of statement for that has completed the effort to decide case to be applicable. In my case, it was 6
Madam, your voice is cracking. You can come to the court. You can come to the court on Tuesday. You please come to the court. Your voice is cracking.
on Monday.
On Tuesday.
Sorry, ma'am.
On Tuesday. Tuesday is holiday.
Wednesday is
On,
First April.
we can post it on Monday.
In my case,
इसको Monday रखते हैं. ठीक है? Are you basically this is the main judgment? This Harinandan Prasad is the main judgment?
We'll examine it eventually.
You examine it.
We'll examine.
The learned counsel for the parties are present. Mrs. M.N. Pal, senior advocate, has joined online, but due to poor connectivity, the matter could not be heard. At the joint request of the learned counsel for the parties, pose this case on Monday under the heading for final disposal. ऊपर लिखिएगा. The learned counsel for the petitioner has submitted that the case of the petitioner is squarely covered by the judgment passed by the Honorable Supreme Court reported in bracket 2014 bracket close 7 SCC 190.
मेरे submission में मत लिखो.
नहीं,
इनके
as
submission.
for the respondent,
Respond.
है ना? Fully covered by the judgment reported in bracket 2014 bracket close 7 SCC 190. Harinandan Prasad and another versus employer / management of Food Corporation of India. Post on Monday for final disposal. इसमें BSNL वाला judgment को consider तो किए हैं लगता है. This BSNL judgment. Madam, you come on Monday, we will hear you. Should I post it at 2:15? At 2:15? Okay, at 2:15. On Monday, madam, at 2:15? Okay, please come. MS Rukmani का नाम. Rukmani लिखते? Yes.
After case item 8, WPL 2715 of 2023.
Who is for the petitioner? Are you there?
May I please your words?
Yes. Minimum wages.
This is the matter under section 26 of soft and establishment for illegal termination of job as alleged by the respondent, and the London Labour Court has directed to pay between 1 lakh as compensation to the petitioner. Apart from this, it was also directed that the wages, a sum of rupees 9,000 per month, was also directed to pay from the month of June 2020 to March 23. I would like to refer your lordship
Shops and establishments.
section 26 subsection 5 clause B. In passing such order, the prescribed authority shall have power to give relief to the employee by way of reinstatement or money compensation or both. So my humble submission is that your lordship, the wages which was directed to pay after termination of the monthly disposal of the case, that is beyond the law. And that fact was also considered, agreed by the respondent in his
counter affidavit at para 30. You also stated that the learned tribunal rightly allowed the rupees 1 lakh as monetary compensation in the light of section 26(5)(b) of Bihar Substance Establishment Act. The learned tribunal has taken into consideration that reinstatement of the petitioner is not possible as relationship between employee and employer is not good, and as such monetary compensation at the rate of rupees 1 lakh was provided.
So far as monetary compensation is concerned, you have nothing to say.
Yes.
But so far as back wages is concerned, the same should not have been.
Yes, sir. So
Maybe that at the time of calculating the monetary compensation, the wages can be taken into consideration. That what was the wages, what was the circumstances. At best. Yes. What do you have to say?
This is then in addition 125B जो है 26B, this is in addition. He has removed me from the service. Now whether I will be reinstated or not, upon that the learned labor court says no, you could not be reinstated. Take this money for your permanent year. Therefore I was not reinstated. But with respect to the back wages, I was entitled under section 26.
but it's not backward.
It is not back wages. It is only monetary compensation.
My lords, monetary compensation is additional one under section 26(5)(b). In passing such orders, the prescribed authority shall have power to give relief to employee by way of reinstatement or money or compensation or
You
both.
see, under the labor jurisprudence, you get back wages. There is no question of monetary compensation.
My lord,
Right?
this is
The code, this particular act specifically talk about monetary compensation, and you have not been reinstated.
therefore 1 lakh was given only for
Therefore,
that.
1 lakh was given.
Yes.
So therefore, the payment of wages till the date of the award, they have given you compensation for that.
And for the period for which I was out of the service without serving of the notice, for that period I will not get anything.
I do not know. You have to show me some law. He's saying that the under the act there is only power to give
My lord,
monetary compensation. Tell us.
that is in addition to the original power.
We do not know. You have to show me some law. Because we have not come across any situation where back wages as well as monetary compensation both are being paid. At least I have not come across any such award in labor matter where back wages and monetary compensation. It is not cost, it is monetary compensation. Both is not payable. How do you justify payment of both?
If my lord will take note of section 26 for a moment.
Yes, 26.
Proviso part.
Proviso.
26(1). In total, my lords, may be permitted to me. 26. No employer shall dismiss or discharge or otherwise terminates the employment of any employee who has been in employment continuously for a period of not less than 6 months, except for a reasonable cause, and after giving such employee at least 1 month notice or 1 month wages in lieu of such notice, provided that such notice shall not be necessary where the service of such employees are dispensed with on a charge of such misconduct as may be prescribed by the state government, supported by satisfactory evidence recorded at an inquiry held for the purpose. Provided that further that employee who has been in continuously employment for a year or more and whose service are dispensed with otherwise than on a charge of misconduct shall also be paid compensation equivalent to 15 days average wages for every completed year of service and part thereof in excess of 6 months before his discharge, in addition to the notice or in pay or in lieu of notice prescribed above.
That's right.
Therefore, my
So
lord,
this is compensation.
this is one of the 15 days time. This is the salary. This is the salary for which, my lord, I was out of the service due to his conduct. Firstly, my lord, he has to give notice to me. If without notice he has dismissed me, then for every month.
15 days average wages for
Yes.
every completed year of service.
Yes.
For 1 year, you will get 15 days wages. Not every month of service, every year of service. you get that? And this is the compensation that he has given by way of 1 lakh. There is no question of any back wages in the manner he has given. He has given you a full back wages, right?
My lord will examine 26(2) Roman 4.
Roman 4.
This is only with respect to, my lord, is saying section 26 clause 1. In 26(1) I am entitled, in 26(5)(b) also I am entitled.
Show me that in 26(1) you are entitled. The quantification is there in 26(1) in second proviso. 15 days for every year of service. Isn't it?
इसमें तो कुछ टाइम दे दीजिए।
अब टाइम नहीं देंगे हम सुन
ठीक है जी, तो मेरा यही केस है। ये तो जो हमारा 26 इसको नोट कर लिया जाएगा जी। 26(1) में भी इंटाइटल है और 26(2) क्लाउज 4 रोमन 4। This amount was given to me with respect to my wages for a month, and this is with respect to not reinstating me 1 lakh was allowed.
लिखिए। WPL number 2715 of 2023. Heard the learned counsel for the parties. This petition has been filed for quashing the judgment and order dated 21/3/2023 passed by learned presiding officer Labour Court Dhanbad in connection with JSE case number 01 of 2021, whereby the said court has been pleased to direct the petitioner to pay wages at the rate of ₹9,000 per month from the month of June up to March 2023 to the respondent, and in addition there is also a direction to pay monetary compensation to the extent of ₹1 lakh. The petitioner has been directed to pay this amount within 60 days from the date of the order, failing which it has been directed that he would be liable to pay interest at the rate of 10%. Similarly, the learned counsel for the petitioner, while assailing the impugned order, has submitted that the impugned order has been passed under section 26 of Jharkhand Soft and Establishment Act 1953. He submits that the impugned order has directed the petitioner to pay monetary compensation in terms of section 26 within bracket 5 within bracket B, and has additionally directed the petitioner to pay wages at the rate of 9,000 per month from the month of June 2020 to March 2023. The learned counsel has referred to the provision of section 26 and has submitted that there is a clear provision that by passing the order, the prescribed authority under Bihar Shops and Establishment Act 1953 shall have the power to give relief to the employee by way of reinstatement or monetary compensation or both. The learned counsel submits that reinstatement has been denied. Denied, है ना?
It's because he was aged about 80 years.
Reinstatement has been denied in view of the fact that the respondent was aged about 80 years. कहाँ है?
Impugned order में your lordship.
कहाँ पर है? इसमें तो नहीं दिख रहा है.
Just
Age मत. The learned counsel submits that the learned court has refused to grant reinstatement and instead monetary compensation has been awarded. But direction to pay back wages is perverse and calls for indifference.
your lordship, page 23.
Yes.
Paragraph 6.
Okay. The learned counsel has pointed out that it has been recorded from the evidence of AW1 that in the year 1961 the respondent was about 18 years of age and now he was 80 years of age. The learned counsel appearing on behalf of the opposite respondent has opposed the prayer and has submitted that the award of monetary compensation is in terms of section 26 within bracket 5 within bracket B of the Bihar Shops and Establishment Act 1953. But so far as back wages is concerned, it is relatable to second proviso to section 26 within bracket 1 and also section 26 within bracket 2 within bracket Roman 4. The learned counsel submits that the direction to pay back wages and also monetary compensation is in accordance with law and there is no perversity with respect to direction to pay under both the heads. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the application was filed before the presiding officer Labour Court Dhanbad and was numbered as JSC case number 1 of 2021 under section 26 of Jharkhand Shops and Establishment Act for reinstatement and back wages. It was the case of the respondent that he has been working in the establishment of the petitioner since 1961 and at that point of time his age was 80 years. And at the relevant point of time In March 2020, due to lockdown, he became idle, and after lockdown, in the month of June 2020, the establishment started running again, and the applicant was terminated after adjustment of rupees 5,388 paid in advance. Before the Learned Labour Court, it was a specific case of the petitioner that the applicant was that the of the management of the establishment that the applicant was neither appointed as employee nor his services were terminated, and the provisions of section 26 was and the petition under section 26 was not maintainable. The learned court framed the following issues. The evidences were led by the parties, and the issue number 2 was decided in favor of the applicant, to which there is no challenge. Issue number 1, 3, 4 and 5 were taken up together, and it has come in the and it has been held that, and it has been observed that the Bihar Shops and Establishment Act and its rules cast mandatory duty upon the employer, and under section 19, the employer is responsible for payment of all his employees, and no employer, and as per section 26 within that is 1, no employer shall dismiss or discharge or otherwise terminate the employment of an employee who has been in employment continuously for a period of not less than 6 months, except for reasonable cause, and after giving such employee at least 1 month's notice or 1 month's wages in lieu of notice. The learned court also recorded that the salary of the applicant must be around 9,000 per month in the month of June 2020. The learned court considered the provisions of section 26 within bracket 5 within bracket B of Bihar Shops and Establishment Act, and was of the view that the said provision provides that the relief by way of reinstatement or monetary compensation or both can be given to the employee, and observed that the relationship between the employer and employee was bitter and would create problem to the employee, and hence a sum of rupees 1 lakh was fixed as monetary compensation. And also directed payment of wages at the rate of rupees 9,000 per month from the month of June 2020 to March 2023. Upon perusal of section 26 of the Bihar Shops and Establishment Act, this court finds that as per second proviso to section 26(1), it has been clearly provided that an employee who has been continuous employment for a year or more and whose services are dispensed with otherwise than on charge of misconduct shall also be paid compensation equivalent to 15 days average wages for every completed year of service and any part thereof in excess of 6 months before his discharge, in addition to the notice or pay in lieu of notice as prescribed. The report, further section 5, section 26 within bracket 5 provides that the prescribed authority shall have the power to give relief to the employee by way of reinstatement or monetary compensation or both. This court finds that in the present case, the learned court has given monetary compensation in lieu of reinstatement, but has given back wages for the period from June 2020 to March 2023. That is from the date of termination till the date of the interim order. This court finds that the payment of back wages from the date of discontinuation of service till the date of the award is not contemplated in terms of proviso to subsection 1 of section 26. 26(1) में तो ऐसा computation नहीं है back wages का, and accordingly the same cannot be sustained in the eyes of law, and consequently the impugned judgment granting back wages from the date of discontinuation of service till the date of the award is perverse, which is hereby set aside. And so far as the grant of monetary compensation with interest is concerned, the same does not fall for any interference.
ये जो पटना हाईकोर्ट का जजमेंट है उसका पैराग्राफ 9 खाली कोट कर दिया था।
The perusal of the impugned judgment does not reflect that any evidence was laid with respect to the wages which was paid to the petitioner prior for the entire period of completed period of service. वैसा तो कोई एविडेंस भी नहीं
बिल्कुल।
आया कि कैलकुलेशन भी हो जाए।
ना कोई नहीं।
कि जो पटना हाई कोर्ट का जजमेंट था
ऑर्डर होने के बाद ये सब जल्दी नहीं हो सकता ना, पहले दिखाना चाहिए।
अभिलाष
Item 13, WPL 7020 of 2011.
यस पिटिशनर।
In this case, the challenge is on the ground. Before showing the documents, I am placing it in my language. I am placing it, my lords. The earlier, my lords, almost for the same period, only 2 months were different. Proceeding was initiated but dropped. Subsequently, my lords, without any, there was no ground at all to reinitiate the proceeding. Suddenly, by adding 2 more months, proceeding was initiated. And it was not even clear, my lords, as to for what period it was initiated, but one form was given to us in which period was mentioned. Subsequently, order has been passed against us. Then, my lords, we filed a writ petition for this honorable court that was rejected on ground of alternative remedy. Then we moved for appellate authority, my lords. LPA was also filed. LPA was dismissed because alternative remedy was there. Then we moved for appellate authority. Our appeal was rejected. Then we moved for Honorable Delhi High Court. Honorable Delhi High Court said that since the works are in this place, therefore we should move for this honorable court. Thereafter this case. I only show 3 documents to establish my contention that once the order was passed, the same authority could not have reviewed it first, and it is not even review, it is simply saying it is a new proceeding. That could not have been done. My lords will kindly come to page number, for a moment, my lords, page number 26 and 27 are the, my lords, earlier order. 1 page orders, I am just showing it for the purpose of showing the period, my lords. Next one is a notice. If my lord will come to 3rd paragraph, page number 26. Penalty was imposed for delay in submitting the PF bylaws. It is not in dispute that the amount was submitted. Page number 26, para 3, last line, my lords. Period has been mentioned by pen, my lords.
Last line.
Para 3, last line.
Yes.
5 by 75, 12 by 84, 10 by 85, 4 by 86, 6 by 86 to 8 by 86.
5 by
75,
75.
then minus 12 by 84, then October 10 by 85 minus, then 4 by 86,
4 by 86.
6 by 86 to 8 by 86.
6 by 86 to
8 by, this was the notice one issued to us previously. Then my lords, order is at the next page, my lords, page number 27. And operative party, my lords, page number 28. Last paragraph I'll place, my lords. Last 2 paragraphs. Page number 28. My lords. May I read, my lords? The establishment contended that since from their side the payment was issued or bank advice was made well within the prescribed date, including the date of normal grace being allowed by the department, there was no fault on their part, and if any subsequent delay is caused in crediting the amount to PF account by the state bank authority, for such lapses the establishment should not be held liable. Establishment has also shown the supporting paper to substantiate the standpoint. Then, my lords,
it was dropped
dropped
by a reason not.
by region order. Then, my lords, again this notice, which is the order, my lords, which is included prior to that, this notice dated 14/6/2002, annexure 3, next page, my lords.
Yes.
Page number 29. In this, my lords, there are 3, my lords, we'll see for a moment again. Last line, it is mentioned 1284 to 698. So it appears that from 1284 to 698 there is violation. Now, my lords, will again kindly come to directly to page number 34. For a moment, madam, this is the period for which second notice has been issued.
This was also dropped.
No, this was the order is against
No,
us.
but this
This
page
is
number
34, madam. This was the only thing provided to us. Now,
this
madam,
is the calculation.
My lords?
This is the calculation.
No, 12 period, month of default is on the left side, was extreme
Yes,
left.
yes.
Month of default.
Okay, this was provided along with this notice, annexure 3.
Yes, ma'am.
It can't be any.
Subsequently, not with this notice, when we submitted our matters representation, they have admitted this. It is in the counter evidence also they have admitted this. They are saying that our contention that details were not provided is falsified by our own statement that database 2 was provided to us. It is not in dispute, my lords.
This was.
This was the, my lords, database 2. We have stated in our petition that no details were provided to us except this database 2.
Okay.
And they are saying that this our statement is falsified by the fact that we admit that database 2 has been provided to us. So this is not in dispute. Just for my satisfaction, I will firstly note this, not that I show the input order. Month of default. 1284.
Same period.
ये सब इसमें से केवल माय लॉर्ड से लास्ट वाला जो है 2 मंथ अलग है.
क्या है?
ये 486 भी वहाँ 686, 786, 886 लास्ट मंथ एक 698 जोड़ दिया गया है.
पढ़ा नहीं जा रहा. 698.
698 है माय लॉर्ड.
Type copy 5 886, 898 आपका टाइप कॉपी में तो कुछ और ही है.
वो 898 या 698 है. वो टाइप पढ़ा ही दे रहा था तो कुछ टाइप नहीं.
फिर आप कैसे बोल रहे हैं कि वो क्या पी है?
हमको दिख रहा है, वो देख रहे हैं.
टाइप कॉपी में भी आपका मैचिंग नहीं है.
इनका
उसके बाद बताइए.
इनका 698 ही एक नया है माय लॉर्ड. अदरवाइज ऑल पीरियड वाज प्रायर कवर्ड इन द प्रायर प्रोसीडिंग इटसेल्फ. Then, my lords, the impugned order, my lords, will see for a moment, page number 30. It is small order, my lords, first page itself, I am reading, my lords. Messrs. BOC India Limited, such and such establishment covered under such and such, scheme from there and such and such. Then, my lords, and the fifth line, administrative charges and inspection charges within 15th of the following month, if the establishment fails to deposit within stipulated date. Penal damage as per the provisions of section 14B of the Act is required to be imposed. Now, my lord, second, my lord, see for a moment. The establishment Messrs. BOC India Limited.
Page 36.
30, my lord, 30. Annexure 4. इसका first paragraph important, second paragraph देख लीजिए, my lords. The establishment of Messrs. BOC India, Mona Road, Darwa Mines, bearing code number such and such, failed to deposit their forfeit due for the above period. Accordingly, a proceeding under section 14B of Employee Provident Fund was drawn against the establishment, and a notice was issued to show cause by penalty as per the provisions of section 14B shall not be imposed. Notice was issued by this office letter number such and such, dated 14/6/2002, fixing 11/7/2002 as the date of hearing. On 11/7/2002, Mr. S.K. Sen Gupta, operation manager, appeared on behalf of the establishment and admitted the delay in the goods as per details given in database 2. This was why I was pressing my lord. Then, my lord, this is the calculation and penalty has been imposed. Now, my lords, on top of this page, my lords, you see for the period from 1284 to 698 on top. So, the periods are same except 1 month, my lord, that is 698. Now, my lord, for a moment come to the appellate order, that is at page 36. My lord, sir, come to that. Then, my lord, paragraph 2, my lord, the statement which I am just making has been said that the case of the appellant is that appellant is a company covered under EPF Act. It was paying EPF contributions regularly. EPF authority started the proceeding under section 14B, alleging that there was delay in the period December 84 to June 88 and levied the damages interest which is illegal one. The case of the respondent is 88 जो लिखा हुआ है 98 होना चाहिए. The case of the respondent that as per there was delay in report of EPF contribution, damage interest was correctly imposed. He contended that delay in initiating the proceeding caused prejudice and notice was defective one. The line advocate for the respondent supported the applicability of the EPF Act and default is not disputed. It is stated in the appeal memo that the appellant paid only up to 1985. It is true that there was some defect in notice, but there is no material to hold that such defect caused any prejudice. The delay.
Did you inform them? Did you place it before the tribunal that there was already an order? dropping.
my lords.
This is all together in new ground. Here.
No.
New ground, but you, what have you done? You have also done something. You initiate a proceeding and drop it. At least overlapping you can't do, isn't it? Fair enough. इसके अलावा क्या बचा है? ये जो डेटाबेस में जो है आप दिए हैं, this is the database. इसके अलावा कोई डेटाबेस regarding delay. Tell us. This is database too. You have filed your counter affidavit also. This document is not disputed. इसका period देख लीजिए.
ऊपर में दिखलाते हैं पीरियड में,
हाँ.
इसी डाटाबेस के ऊपर में ईयर 84 85
हाँ.
85 86
हाँ.
देन 86 87
Yes.
98 99
Fair enough. और इसमें जो पीरियड जो मंथ ऑफ डिफॉल्ट दिखा रहे हैं वो तो इसी पीरियड में आ रहा है ना. इसी 84 85 आप दिखा रहे हैं और 12 84 दिखा रहे हैं, तो सिर्फ उस मंथ का डिफॉल्ट है. देन यू हैव 85 86 राइट.
85 को लें
Then 10 85 का डिफॉल्ट है. Then this 85 86 12 85 का है, 86 87 486 का है.
yes ma'am,
पूरा साल का डिफॉल्ट नहीं है.
and thereafter my lord 686 4 periods are my lord different.
हाँ 686 इज देयर.
हाँ, उसके बाद वाला 4 रोज है
खाली एक
कौन सा
पीरियड
चार कौन सा पीरियड है उसके बाद?
after
So
486
therefore, whatever is overlapping with the earlier period cannot be realized because that has attained finality. Right or wrong, you have passed an order, isn't it?
my lord.
गलत ही ऑर्डर किए हैं, लेकिन क्या करिए. गलत किए हैं सही किए हैं, I should not come in. That is your wisdom at that point of time. You have passed an order. So whatever is overlapping, that has to be excluded. This aspect may not have been placed before the learned tribunal, but it is your document. They can place it even in the writ records, isn't it?
This
ये जो आपका ये जो डेटाबेस ये लगाए हैं यहाँ पर,
पेज 34
हाँ, इसमें कुछ कैलकुलेशन दिखा है क्या? इसमें कुछ टोटल कैलकुलेशन?
ये कैलकुलेशन टोटल नहीं है, हर एक उस महीने का खाली डिफॉल्ट दिखा रहा है, क्या क्या जमा हुआ वो दिखा रहा है. इनका कहना है कि वो लेट से जमा हुआ है.
वो 2 दिन भी लेट होता है.
हाँ, उसी के लिए माइनर सी ले रहा है, इसी के लिए ये ले रहे हैं. और प्रीवियस ऑर्डर में वेल रीजन ऑर्डर था, उसमें लिखा हुआ क्यों डिले हुआ है.
रेमिटेंस में डिले, रेमिटेंस में डिला हुआ है बैंक से. वो तो आपके खिलाफ जजमेंट है, लेकिन दे हैव ड्रॉप्ड इट, सो वी वांट टू से
वो सही ठीक हुआ.
रेमिटेंस में डिले होने से कुछ फर्क नहीं पड़ता है. यही ऑर्डर कर देते हैं. WPL number 7020 of 2011. Heard the learned counsel for the parties. This petition has been filed for the following relief. The learned counsel for the petitioner submits that a show cause notice was issued to the petitioner as contained in Annexure 1 dated 23/11/1987 alleging default, alleging delayed payment for certain months. Those were 575, 1284, 1085, 486, 686 to 886.
one thing is that my lord, some different accounts number are also there, so that will be verified my lord at the time. My lord will give me time.
कौन सा अकाउंट है?
Page number 31 if my lord will kindly come.
Yes.
AC number 01, then 10, then 02.
इससे नहीं होता है ये एस्टैब्लिशमेंट का कोड से चलता है.
डाटाबेस में लिखा हुआ है ये चीज.
establishment कोर्ट से चलता है, but I will remit it to you. You verify it.
Yes, ma'am.
ठीक है?
हाँ,
The learned counsel submits that the proceeding initiated pursuant to show cause dated 24/11/1987 was ultimately dropped while order dated 14/3/88 by a detailed order. He submits that thereafter another notice was issued dated 14/6/2002 alleging delay in remittance of Employees Provident Fund amount for the month 12/84 to
698.
6/98. He submits that especially the period was overlapping as compared to the earlier notice for which the proceeding was dropped. He refers to the final order passed therein and submits that demand of rupees 1,89,439 was raised after showing remittance of 9,14,695. He submits that the representative of the petitioner had admitted the delay in deposit as per details given in database 2. The database 2 has been annexed along with the writ petition as annexure 6
Yes, ma'am.
at annexure 6, and he submits that the period of default is again shown for the period 12/84, 10/85, 12/85, $12.84, $12.85,
1284, 1085, 1285. Then, my lords,
$12.84, $10.85, $12.85, then $4.86. Let's go at the price.
686, 786, 886.
686, 786, 886,
And then, my lord, 698.
and 698.
My lord. Only this is different.
He submits that 786 का तो नहीं रेज किया पहले?
किया
नहीं किया था. He submits that
6
only
to
the
8.
last entry,
Yes,
that is 698,
yes, sir. That
was
is
different
my lord.
as compared to that of the show cause dated 24/11/1987. The learned counsel submits that once the proceeding in connection with the period mentioned in the show cause dated 24/11/87 was dropped, there was no occasion to initiate fresh proceedings, and therefore the demand in connection with overlapping period cannot be sustained in the eyes of law. He has submitted that the matter was challenged before the learned appellate tribunal, but the appeal was dismissed. He has also submitted that although from the order passed by the learned appellate tribunal, it is not apparent as to whether this fact was brought to the notice of the appellate tribunal, but his case is based on the documents of the respondent and a counter affidavit has already been filed. Therefore, the respondents cannot be permitted to initiate proceedings for the period where the show cause was issued and the proceeding was dropped. The learned counsel appearing on behalf of the opposite respondent has submitted that the matter may be remitted to the Concerned authority.
I would be,
What do you want to say?
it will come from the
But you justify your action.
well, I have argued that
The learned counsel appearing on behalf of the respondent
this is first
has submitted that the matter requires verification and therefore the matter be remitted to the respondent number.
respondent number.
3, madam.
Respondent number 3.
Yes. He has filed something.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that once a show cause was issued in connection with a particular period of default and the proceeding was dropped, then under such circumstances there cannot be any occasion for the respondents to initiate a fresh proceeding for the same period and pass a different one. This court finds that the proceeding was initiated by notice dated 24/11/1987 for the period of default mentioned as in the notice itself as 575, 1284, 1085, 486, 686 to 886, and the proceeding was dropped by a detailed order as contained in order dated 14/3/1988, primarily referring to the delay in remittance from the bank account. However, the said order appears to have attained finality. After a considerable passage of time, another notice was issued, which was overlapping as indicated above, and a fresh order was passed, raising a demand of rupees 1,89,439. And as per database 2 annexed in Annexure 6, it appears that the period which was mentioned in notice dated 24/11/1987 was almost the same as mentioned in database 2, except additional period for a month in the year 1998. Considering this aspect of the matter, this court is of the considered view that no demand could have been raised by the respondents for the period for which the proceeding was already dropped. However, the matter is required to be verified by the respondent number 3. Accordingly, the matter is remitted to respondent number 3, who shall verify the records. If the respondent number 3 is of the view that who shall verify the records and pass an appropriate order after granting an opportunity of hearing to the petitioner without being prejudiced by the interim orders passed in